Chair now recognizes the gentleman from North Dakota, Mr. Kramer, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Administrator, for your candor, for being here, and for your strong leadership. And I might just say, you used a term in responding to Mr. McNerney that I think is a new term at the EPA, and that was partnership. And I think that my friend from California's line of questioning bears out that you see states as stakeholders and partners, not as subordinates. Thank you for going to places like Oklahoma and North Dakota and other states in the middle of real America that are affected by what for the last 8 years has simply been a dictatorship by the EPA. So thank you for that, and we appreciate your willingness to address us in our home states. I also want to congratulate you on your incredible work on meeting these deadlines. 27 years that gets done in a matter of weeks and months. It probably shouldn't be such a high, seem like such a high standard, but by comparison. And doing all that with only one confirmed AA is really quite remarkable. So I look forward to when you have a full staff and a full team and we can really get to it. And I know CPP and WOTUS they're big topics, obviously, in North Dakota, as you know. But I want to get to the heart of a couple of things that you've emphasized. And like my friend from Texas, Mr. Olson, I appreciate your commitment to process and rule of law. I appreciate your commitment to cooperative federalism. And I know you're very familiar with a couple of North Dakota cases, one in particular, of course, the regional Hayes case that was started in California. North Dakota was blocked from intervening in, which is just kind of blows me away that states don't have as a matter of right, constitutional right, standing in cases that affect them, especially with regard to regulations that they have primacy over regulating. The more recent one is one that sort of straddled your memo on sue and settle that I want to bring to your attention and see if we can't work more closely together, you, me, our Attorney General, on addressing it as we go forward. And that was a revision of rules that was proposed in 2016. A consent decree was declared between the EPA and some environmentalist groups, and North Dakota was blocked from intervening. And this is related to oil and gas industry in our state, where our state has primacy. We were blocked from intervening. Oral arguments in October of this year, about the same time as you were putting out your memo, occurred in the D.C. Circuit Court of Appeals, and we were blocked again. The environmentalists and the EPA prevailed. But what was most disturbing about that, and why I want to bring it to your attention, is because you have a really big task in front of you to meet not just the rules, but the culture change that we hope to achieve. And that is that it was the Department of Justice attorneys that argued so effectively against the state of North Dakota in the D.C. Circuit. So as we go forward, what I'd love to do is be able to, maybe have a meeting with my Attorney General and you and me and plan, the next phase of this and use the state of North Dakota as a partner as opposed to, a litigant on the other side.
Yeah, as I indicated earlier in my opening comments, and I think in response to questions, from your perspective, you have put into place a process by which we're supposed to adopt rules, and rules are supposed to be what? Laws of general applicability. And so when you are involved in litigation and you change requirements under a statute, discretionary to non-discretionary, timelines or otherwise, and then you apply it in a general fashion, that's something that I think is offensive with respect to the APA process and should be dealt with. And that's why the sue and settle practice is important as we go forward. We may consider codifying that, loosely said, with respect to rulemaking, but it's important that we implement this directive I've sent to respect the APA as we make decisions.
Well, with regard then to states' rights, because I really feel like it's not just RCRA, it's all of the acts under the EPA, it's several other agencies where it seems like the right for a state to have standing somehow has to be based on a finding of harm or injury. And it seems to me that in a cooperative federalism, states should just have that right, especially if it's regulation that they have primacy over. I'm wondering if we should be doing something, to codify that, which it seems to me the Constitution should be adequate for, but whether we should do it broadly or whether we should do it very specifically, and I might add, and then you can answer and wrap up my time, should you have some more independent litigation authority, independent, say, of the DOJ or other?
Well, look, I think on the first point, I do think that perhaps Congress addressing the standing of states to address some of those, most of those are state implementation plans. Many deal with regional haze requirements under the Clean Air Act. And I do think it's important that the voice of those states are heard, and that's the reason, as it relates to the directive that I issued, we asked Justice to take a very accommodating posture with respect to state intervention on these issues. But there probably is more that can be done to make sure that that happens going forward.
Thank you, and thank you for your service.
Time's expired.